It also has some challenges that we'll examine throughout the webinar. And we wanted to make this webinar as useful as possible to our respective member tribes. And with that said, we're going to hear from a number of people that we have on the line, and we'll be calling on them throughout the webinar to give their thoughts on the guidelines. Specifically, on the call today, we have Chairman Ron Allen from the Jamestown Squam tribe, the chairman, Chief Minerva from the Mohegan tribe. We also have John Dossett, who's with us from the National Congress of American Indians, Aaron Klein, who is a consultant for NAFOA and the prior Deputy Assistant Secretary for the Department of Treasury, Robert Yoder from Yoder and Langford, Kathleen Millett from Holland and Knight, Mary Strike from Dorsey and Whitney, and Wendy Pearson from Pearson Law Offices. Many of you probably recognize those names. These are names that have been with us from the very beginning when with this issue. And with that said, we also want to try to set up and define some of the terms that are going to be used, and also look at this webinar from the perspective of change from the 2012 guidance till now, and really looking also forward to what are the next steps for tribal leaders, and then of course taking your questions and comments throughout. So we are going to call on first Chairman Ron Allen, and we're hoping that the chairman could give us a little bit of background on how things have got to this point and some of the his guidance.
Okay, Dante, it's Ron. Can you hear me okay?
Hear you just fine, Chairman.
Okay, thank you. And thank you and NCAI, Nigel, and whoever else has been helping coordinate this whole effort. I really appreciate your leadership here. And I definitely appreciate the legal and technical support that has assisted our tribal leaders with regard to this initiative. From my perspective, this is a very clear and a very encouraging victory. You know, without a doubt, as we all know, political realists, we didn't get everything we wanted, but we got a lot of what we asked for, and I think that since this whole initiative started a number of years ago, and we've had numerous consultation sessions, private sessions with the Treasury and IRS to discuss how to remedy this this problem that tribes have been experiencing with respect to IRS requiring 1099s on a whole variety of what we believe are appropriate exempt categories for cultural reasons, educational reasons, housing assistance, etc. So there's a long list of things that I think that this new guidance is addressing that we were concerned about. So it is definitely a foundation we can build on that's going to really help us immensely as we try to address the countless needs for our community. So all those who have contributed to the countless letters and in the recommendations based on the initial guidance draft that was out there and discussed with the tribe, this, quite frankly, is a very positive move. And so the question in all of our minds now is how we take it and make sure that there is appropriate training for all of those agents in the respective regions. So I'm really very, very delighted about it. I'm looking forward to the follow-up discussions that we'll have and trying to make sure that it is interpreted as broadly as reasonable in terms of addressing the kinds of exempt activities, exempt assistance that tribes are providing our community, from the elders to the spiritual leaders to the economic disadvantaged, et cetera. So I thank you guys all, and I think that this is a good benchmark for us that we can look back at and say, we did good here. It took us a long time, and many of us were worried that it was slow in the coming, if you will, but they produced. You know, they heard us at the last session that don't sit on this thing forever. You need to move it and so we can get on with the additional requests that we'll be seeking. So thank you.
Well, thanks, Chairman. And I think it's worth noting that the guidelines, if we carefully read through these, a lot of our comments were taken to heart. And I do thank again some of our partners who have submitted comments in response to the general welfare guidance. NCAI, NAFOA, AT&I, CATG, the California Association of Tribal Governments, United South and Eastern Tribes, Midwest Alliance of Sovereign Tribes, and the United Indian Nations of Oklahoma, Kansas, and Texas. So we appreciate everyone's efforts on that. And we're going to turn now to Chief Malerba, and I think, Chief, you wanted to comment a little bit on the guidance itself and maybe some of the impact.
Yes, hi, this is Chief Malerba. I did want to talk a little bit about that. I would echo Ron's comments, though, that, and everyone else's comments, that this is really a success here. When you think about the fact that, this has been a dual-track strategy, but it also has been a huge coalition of tribes, tribal organizations that have gotten us to this point. I think it's really important. And when you think about, the administrative track and the way we, and the way we started proceeding with that, we began in March, 2012 with joint comments. Again in June of 2013 with joint comments, and then finally in June 2014. So, this is a huge achievement, and I think what's really important to note is the fact that, so oftentimes we have consultation, but yet our attitudes and our opinions are not included in the final guidance. In this case, absolutely, not only were we heard, but I think that both IRS and Treasury has really tried very hard to incorporate what they've heard and what they heard from Indian country. So as we go forward, I think we need to improve on, 2014-35 by looking at, legislation. And I know that that's really been used as position all the way through, that we should be supporting HR 3043 and supporting Senate 1503 in their current iterations, which will really improve on the guidance and codify the guidance. But in terms of the importance to Indian country, what's so important to us is rebuilding our communities and being able to independently provide services that we identify as sovereign nations that are important to our communities, to strengthen them and to build them. And for us as individual nations to identify what's most appropriate, most important, and what will add the most value to our communities. And I think that this is a huge step toward that. And again, I think, congrats to everyone who's worked on this. And I think, we need to thank our federal partners as well. So I would end with that.
Well, thank you, Chief Malerba, for your comments, and Chairman Allen. And I know both of you may have to step off soon, but we appreciate you jumping onto the webinar to express your opinions on the guidance. And I think what we're going to do now is turn to John Dossett from NCAI and maybe get on the same page with some of the concepts that are brought up, and also talk a little bit more about the background leading up to this. John?
Thanks, Dante. This is John Dossett, General Counsel at NCAI. And I think like a lot of us, I started reading the new guidance that came out 2 days ago, and I realized very quickly that I needed to review. And I think that's what we're going to do real quickly here, is kind of review the guidance, the new guidance, and the differences. Let's start first. The thing that we have here is called a revenue procedure. And Mary Straits, one of the attorneys, the tax attorneys we've worked with over the years on this, can tell us, what is a revenue procedure generally? What is this thing?
It's a published position of the IRS. It's just short of regulations in terms of its status in the hierarchy of administrative authorities. It's something that the IRS is bound by. And as distinguished from revenue ruling, which deals with a resolution of a question of law, substantively, what this deals with is a statement of procedure. And in this case, it's a statement of procedure that outlines the service position generally on the general welfare doctrine, and goes on to say how it would apply to tribal government general welfare program, and then it outlines certain categories of programs that the IRS says in these procedures that it will treat a certain way, i.e. favorably, and we'll be covering all those ways throughout the webinar.
Thank you. One question for you, Mary. Can tribes, well, let's say that you know, an IRS examiner comes to the tribe and starts bugging them about one of their programs. What do tribes, can they rely on this revenue procedure? Can they just give them a copy and say, hey, wait a second, look, we have a safe harbor here. What should tribes do with this thing?
Well, that's a broad question. I mean, I think if you're at the audit stage, you kind of have to live with whatever programs you have because the IRS is already there. But if something falls within the safe harbor, if a program that the tribe has falls within the safe harbor, the agent would not have any discretion, assuming there aren't any disputes about what the safe harbor means. The agent wouldn't have any discretion to say the program is taxable.
All right. So this
that's maybe a little bit oversimplified, but it gives a lot of certainty for tribes for those programs that are described in the safe harbor. So it should streamline audit.
All right. Let's go on to the next slide. And the next slide is about the concept of a safe harbor. And I was going to ask Wendy Pearson about this one. This is a use of the term safe harbor that it sounds like a nautical term at first, but it's not. What does the IRS mean when they say something is a safe harbor?
Right. Well, a safe harbor is a provision in a law or regulation, or in this case a procedure, that affords the taxpayer protection from liability or protection from penalty if certain conditions are met. So in this case, this revenue procedure has set up all of these different program safe harbors that if the tribe meets the parameters of the safe harbor set out here in both the general parameters, the general guidelines, and then the specific guidelines for each type of program, then the IRS, as Mary was alluding to, the IRS cannot assert tax liability or penalty against the tribe if they meet the safe harbor. And the safe harbor specifically, as it relates to the general welfare exemption, is a presumption that the need requirement is met, and thus the exclusion from tax would apply.
All right, thanks, Wendy. Going on to the next slide. If we
Well, John, if I can just ask a question of Wendy really quick.
Oh, sure.
Just because something is listed in the safe harbor, is that the limit of what tribes can set up, or is there outside discretion?
No. So the safe harbor does, this revenue procedure sets out safe harbors, but it doesn't limit the types of programs that a tribe can have. So if the tribe has a program that's not defined in this revenue procedure, that program could still qualify for exempt benefits. The beneficiary or the member could be receiving tax-exempt benefits under a different type of general welfare program that could still meet the general rule under the general welfare exclusion, even if it falls outside these safe harbors. So that's a good question. It's important to remember this revenue procedure does not outline or identify the limit of the types of general welfare programs that a tribe could have.
Okay, thanks. Going on to the next slide, maybe I'll briefly describe the general requirements in order to qualify a tribal program as a general welfare program that's not subject to taxation. And there's 6 requirements. First, that the benefits have to be provided under a specific tribal government program. Second is that there have to be written guidelines or qualifications in order to receive the benefit. I don't know that those written guidelines need to be extensive or complicated, but there has to be some sort of written guidelines. The third is that they have to be available to any tribal member who qualifies. And I don't think this is intended that it be any tribal member. The program might, for example, be only for tribal veterans. But so that program would only benefit veterans. But so it doesn't have to be for everybody or every tribal member, but it has to be for generally available to all the qualified people. It can't just be to your favorite veterans. It has to be to all veterans. The fourth is that the benefits can't discriminate in favor of the members of the tribal governing body. So you couldn't use this to set up a program that only benefits the tribal council. The program can't be compensation for services, so it can't be pay. And then finally, the benefits can't be lavish or extravagant. And that's going to be determined by the circumstances surrounding. Any comments on these general requirements?
Well, I think what we can do, John, is look at some of the notable developments, and I think some of these comments that you just raised as general requirements we can elaborate on a little bit more.
Okay. Going on the next slide, then.
Sure. So on the notable developments, we've taken a look at the 2012 guidance and looked at the new guidance that just came out on June 3rd. And some of these developments that we see, or some of the ones we don't see, we wanted to highlight those because those were of concern to tribal leaders in putting together our comments. And first, I see that they've expanded the scope of eligible persons. And Kathleen Nillis, if you don't mind talking about that and maybe what that means, what impact that has.
Sure. The expansion was requested by a number of different tribal organizations, including the Intertribal organization that NCAI, NAFOA, USET, and other groups participated in. And the idea was some tribes would like to offer benefits beyond simply the member, spouse, and dependent. So I requested that, for example, in some cases, and this would be at the discretion of the tribe, if a particular program benefit was extended to descendants of tribal members who were not themselves enrolled members, that would be allowed, and the IRS has agreed to that. They've also agreed to extend it to domestic partners of tribal members, regardless of whether they're legally married or qualify as a spouse. So those are the two main areas in the expansion of eligible persons. And again, not requiring that tribes expand their programs to cover those persons, but allowing the favorable tax treatment to extend if the tribe decides to do that.
Great. And the next one is on the definition of need. And looking at this is a very notable development. And Aaron Klein, if you can talk about the improvements made since the 2012 guidelines.
Yes, thank you, Dante. The basic concept behind general welfare for the IRS's perspective has always been providing for the need, the government to provide for the need of its citizens, which has always been defined as the need of an individual. What the IRS did here in this new updated version is they added a sentence that stated that Indian tribal governments consider not just individual need, but communal need. So this is a real movement from their perspective in terms of providing a position for tribes as if they were to defend programs that were not in this safe harbor under the basis of communal need as a legitimate, clearly legitimate defined criteria for an Indian tribal government to set up a tax-free program.
Okay, great. Thanks for that explanation. And Robert Yoder, I wanted to call on you for the next notable development, which is something we all should be concerned about, is the substantiation requirements.
Sure. One of the things that is nice about the safe harbor is it sets forth some set procedures like written program guidelines that you have to have, and it establishes a bunch of categories of programs that will qualify for this treatment. But then the question has always come up, well, how do we prove that we've got compliance with that? For example, if we provide financial or monetary assistance to a tribal member for educational purposes, what kind of records do we have to keep to show that the funds that we provided really were used for the intended purpose? The initial guidance did not elaborate on that, and I guess the formal sections of this revenue procedure don't either. However, there's some insight now into what the IRS is thinking about in this regard in the preamble itself. And there's a quote in the preamble for those of you who look at it that basically says that to substantiate payments that they qualify for general welfare exclusion, government payers and the recipients must maintain accurate books or records. And these payers and recipients have to keep those books and records at all times available for inspection by authorized Internal Revenue Service agents or employees. So it's clear that that IRS is aware of some of the practical aspects of this. Is that we've got to substantiate compliance. You know, they set forth these safe harbors, but there's still going to be some work behind the scenes that we're going to have to figure out. How do we substantiate compliance? What kind of records do we have to keep? And I think that in the Q&A section, perhaps we'll get some input from some of the panelists, but there's some questions that probably will need to be asked, like, do tribes have to require receipts? Will certification of compliance forms maybe do? Can tribes look to things like travel expense or accountable plan rules for guidance on substantiating compliance? Those are things that have yet to be developed, and I think we'll really need to receive some focus in the near future.
So the idea is that these payments and services may not be taxable, but we should be able to show where the money goes and who's receiving it. So I think that's definitely a difference that we should pay attention to. And that gets to the next one on what is an acceptable payment. And the term lavish and extravagant is used in here. So I was hoping maybe one or two of our panelists can comment on this. Aaron, do you have thoughts on lavish and extravagant?
Yeah. In the original document, the IRS just said that it was anything was lavish and extravagant. One of the comments that we made was that we wanted to put a little more meat on that bone to prevent agents from kind of going off the rails in the application of this. And the IRS heard that, responded back by saying that lavish and extravagant is under the facts and circumstances. This is an important point because, you know, imagine sending somebody to school, you know, doing a tribal benefit for tuition, and it's an expensive college. Well, somebody might claim that's a lavish choice to send somebody to an expensive college. Somebody else would say, well, under the circumstances of going to college, that's a very appropriate expenditure for tuition. If it costs more than a state school, if it's a private school, many people do that. So this under the facts and circumstances addition provides the tribe additional authority and flexibility to justify, if accused of being lavish and extravagant, to present a set of facts and circumstances. To the contrary, it is a signal to the IRS to consider not just the expenditure, but the expenditure under the facts and circumstances of its position as to whether or not it's lavish and extravagant. So there's a new change in the document responding to our request, moving in a positive direction.
So we this is already part of IRS policy, and I think some of the concerns were getting down to the details of what types of countertop you put in, and we have a question here on, you know, does it depend on what the neighborhood is like or what the neighbors think? And this is a term that's already defined, so if we can have one of our panelists talk a little bit about the terminology that is defined and how that's been interpreted in the past.
This is Ron. Can you still hear me?
Yes, Chairman. Go ahead.
Jerry Hayde is here with me. He has a quick question for you guys. Question. I know we have our dental law for a women's assistance plan. It far as one of the criteria is income guideline, because I think it's what we want to do is be able to, when you talk about lavish and extravagant, the key component is income guidelines. Especially when we talk about our food coupon program, is that a suggestion that we continue doing what we've been doing at U Mountain?
Why don't we let Aaron take a crack at that, and then Mary Strites, if you can comment on that as well, that would be great.
Yeah, so the first point I'd make is the purpose of the safe harbors enumerated here are that it's irrespective of the income of the recipient of the individual. So tribes providing these general welfare benefits will be presumed to meet individual need when applied on a tribally wide basis. So as long as it meets the general criteria of being available on a tribally wide basis, any member, assuming there are enough funds, it doesn't require specific means testing of the programs available, just like public school isn't means tested. So in that area, I wouldn't worry. In the lavish and extravagant area, you know, the facts and circumstances of the point, I think, are valuable, and you know, considering other houses in the neighborhood is a reasonable point, especially in terms of, you know, if it's a nicer neighborhood, building nicer level housing would clearly fit under those circumstances.
Mary?
Dante, could you summarize the question briefly, because he was breaking up and I didn't hear it.
Well, I think it's basically how they will interpret lavish and extravagant, and whether or not that might be tied to income.
Yeah. Yeah, it wouldn't be when safe harbors are around, because the safe harbor specifically is there so you don't have to be concerned with the member's income. You know, I honestly think that in the tribal setting, this isn't going to be a real consistent problem for tribes running up against this requirement. Because in my experience, you know, tribes have limited resources and don't do something that under the facts and circumstances somebody might think is lavish and extravagant. But one example I think that might be, and it's such an extreme example that I think it helps illustrate my point. I think we will be able to deal with this. But here's an example. If a remotely located tribe decided to buy everybody, a house, say, and it otherwise falls within the safe harbor, but it's just a monstrous house. That's kind of the situation. A Harvard education clearly isn't lavish and extravagant, because everyone who goes to Harvard is subject to the same tuition. So I do think we're going to be able to deal with it.
Okay, great. And I think we also, when we're looking at substantiation requirements and how to track those, it also goes to the requirements for tribes to have written guidelines. And I think this was something there was some concern about. And Wendy, if you can just comment on what that means for tribes.
Sure. There were some requests, some tribes had requested that written guidelines would perhaps not be required, especially as it relates to custom and practice. For instance, for the custom and practice of perhaps paying something to a religious leader, nominal value, or religious official. And that maybe is more of a practice, customary practice, and there aren't written guidelines. But the IRS did not change the requirements and did not really expand the safe harbors to these unwritten customary practices. So what it means is that for every program for which the tribe wants to fall within the safe harbor, they'll have to have the program guidelines and policies and practices and procedures written in some form or fashion. Which to the third bullet point there on substantiation requirements, I think that also goes a long way towards the substantiation. It helps to establish that the program was set up according to the guidelines and administered according to the guidelines. So that's what the IRS is expecting.
Okay, great. Well, thanks for the panelists for weighing in on those improvements or challenges for the or exceptions from the 2012 till interim guidance to the final guidance. We're going to move on into going over a brief review of the safe harbors themselves and maybe some of the changes from the last guidance that we can take note of. So we're going to start this conversation under housing. And Robert Yoder, if you don't mind jumping in and talking through the housing safe harbor.
Sure. And keep in mind, and I believe we're going to go over now a bunch of categories that fit within the safe harbor. And there's really these two requirements, those 6 general criteria that John spoke about earlier, like the written guidelines that have to be in place for each program. But then the next criteria is really that the safe harbor sets forth 5 qualified purposes that you can fit within. And the first of those is housing, and it's I think a pretty important category, and it applies to principal residences and ancillary structures that are not used in a trade or business or for investment purposes. The basic safe harbor benefits that can be provided under this housing program is to assist or pay, and the new language really is to pay mortgage payments, down payments, or rent payments, including security deposits for those principal residences. Enhance habitability of housing, and such as remedying water, sewage, sanitation services, and now safety issues like mold remediation or heating and cooling issues. To provide basic housing repairs or rehabilitation, or to assist in paying charges for utilities such as water, electric, gas, basic communication services, phone, internet, cable. Most of those benefits tend to be very useful for my client base, and I think that this is a category that is particularly helpful, and the language in the safe harbor is very useful. Some of the key changes that we've got in this area in the final guidance are things that we really asked for. It might be on the next slide. And those key changes, the first one was really the removal of an on or near reservation restriction. Under the initial guidance, it provided these very valuable housing type assistance benefits. However, it was restricted to homes on or near the reservation. We all know that we've got tribal members who live off reservation. Some of the tribes just don't even have enough of a land base to have homes on or near reservation. So we're now able to expand beyond that. We also, they added this ancillary structure in addition to your primary residence. That was requested in the guidance, and one of the examples that came to my attention was in Oklahoma. One of the clients that I have had shelters for some of the weather that they've got to endure. So you've got these ancillary structures to the primary residence that they were concerned about and are now covered. It also added a new down payment assistance example, which was requested in the comments, and the safety example for things such as remediation. So the changes that we got are much more flexible than the housing examples initially were. And even on the utility example that they've got in the new guidance, they now expressly cover communication services like internet, phone, and cable. So this is a real good tribes will find that their programs fit within this category. And as has been mentioned earlier, you're going to want to make sure that your general criteria are met. So those 6 items that John talked about should be spelled out somewhere in a written guideline, and make sure that your purposes are consistent with the new guidance, and if so, you've got safe harbor treatment.
This is Ron. This is very helpful. I guess I'm wondering out loud here, Dante and John, are we going to set up some training sessions, workshops, I guess, for tribal leaders and staff regarding how tribes should consider setting up their safe harbors and identifying guidelines for the different programs, like the example that Robert is articulating. I think that we're going to need some help to make sure we set up our operations gearing up for protection of these services that we're providing our citizens.
Right, and Chairman, this is Dante. I think that's a really good point. We are going to talk about next steps towards the end of this, but I think that your point about training and maybe coming up with some best practices, we've had a question already about trying to make sure we don't get too specific in the programs and the written documents we're setting up, and I think that's a good point to keep that flexibility. But we are, definitely going to have a general welfare session at our conference and have some of these best practices available for anyone who wants to come there. And I know NCAI will likely have some other discussions on this, but I think it's really good that we sort of look at this, analyze it, and see what we can come up with for looking at how we implement these and how tribes can come together and trying to come up with best practices. So thanks for bringing that up. John, did you want to comment on that?
No, I just thought Ron had a good point that there's probably a lot of flexibility here about the way tribes can set up their programs, and so there's one question is what you can do, and then the next question is what you want to do. So those, I think Ron has a good point that there's going to be a lot of work and development on tribal programs probably over the next few years.
Right, and I'm not sure if the other panelists had any comments on that, but we can jump into next steps and what their thoughts are. So if you can think about that towards the end, we'd be happy to take your comments on next steps on getting best practices and training on this. So we're going to jump into education. I think this is one that has also, following housing, has seen some significant changes or final guidelines on some of the safe harbors that we have commented on. So Kathleen Nillis, if you want to comment on education safe harbors and maybe some of the changes.
Thank you, Dante. Yes, the education safe harbors have been improved. And first of all, let me review what was there previously in the notice. There was a safe harbor for providing students with transportation to and from school, tutors, and school supplies. Then there was a second safe harbor for any programs that provided tuition payments and living expenses. It was not clear whether the living expenses did extend under the notice to off-campus housing. That's now been favorably clarified. And it was for students to attend educational programs and seemed to focus in the original notice more on colleges and universities. And I'll tell you in a minute how that's been expanded. The initial notice did not address at all the provision of child care to students or to other tribal members who need child care outside the home for their children in order to go to work. And that now has been added as a fourth safe harbor. And then there was previously a safe harbor which has only been tweaked a little bit, that's focused on providing training and assistance to individuals seeking employment. So to kind of review the the key changes, we can go now onto our next slide. The first change in the first safe harbor was with respect to school supplies and what that means, and it now includes supplies not only for academic programs but also for extracurricular activities at school, including athletics. And then secondly, the second safe harbor was broadened to make it clear that it includes eligible tuition payments, and they define tuition as including room and board where applicable. And this is for both at the college and university level, but also at the high school, the grade school, and even the preschool level, and also including online education where there's tuition charges. So that was very significant. And then, as I mentioned, there's a broad safe harbor, a new one, for providing child care, and the way that reads is it's for providing for care of children away from their homes to help their parents or other relatives who are responsible for their care to be gainfully employed or to pursue education. So it's quite broad, and that was a direct result of comments by several tribal organizations, including those sponsoring this call. And then finally, there was a change in the last safe harbor regarding assistance on training and employment, where you could provide a clothing subsidy for people seeking a first job or just seeking to be reemployed. And initially it had said necessary clothing, and now it's just changed to a more flexible, appropriate clothing, because it's, in some cases, a uniform might not be required, but clothing assistance would be needed just to provide a suit or whatever was required. So that sums up the education changes. And I guess one thing I do want to mention on a note, what was requested by tribes and not included? About the only thing that I can think of, or two things. One was incentive awards, and those are awards that are given to students, usually monetary, when they complete a certain grade or complete a college, complete high school, whatever. That and those are awards that they're monetary in nature and do not require students to use the award to further their education. So those, I guess we have to conclude that the IRS position is that they're taxable unless the tribe were to require that the students actually use those for tuition or to further their education in some way, in which case then I believe they could be characterized as a scholarship. And one other thing not included that I know was requested was, in addition to transportation to and from school, the school in which you're enrolled, is trips to visit colleges in anticipation of possibly attending college, and that was not included.
All right. Well, thanks, Kathleen. It looks like we did see some significant changes. We do have a good amount of questions, and we will get to the questions towards the end. And we are going to be making these slides available to everyone who has registered as a participant. But going on to the next subject of safe harbors is looking at programs for the elderly, disabled. And Mary Streitz, if you can talk about that.
Yes, I'll summarize the basic safe harbors first on the program for the elderly and disabled. These safe harbors apply only for programs for individuals aged 55 or older or who are disabled. And the safe harbors exist for programs providing meals, programs providing home care or daycare outside the home for people in these categories. Certain local transportation expenses. Yeah, actually, it's a broad category called local transportation expense assistance, or improvements to adapt housing to special needs. So the next slide will outline the ways in which the final guidance differs from the proposed guidance. If you could move to that slide, please. First of all, disability is defined in the final guidance, and the definition includes coverage of any tribal code definition of disabled. So if the tribe has a particular definition of disability in its law, that definition will be respected if the tribe wants to use that to define disability for purposes of these safe harbors, or any other programs it wants to establish for the disabled that may not fall within the safe harbor. The final guidance clarifies that the meal programs covered include programs providing meals at facilities similar to a community center, not just programs providing meals at community centers. One suggestion made that was not adopted was to include within the safe harbor grocery money. So really these have to be prepared meals. One safe harbor was taken out from the preliminary guidance. It was the one that covered travel expenses for medical care. The determination was made by the service that that's already excluded under Code Section 139D, which provides a broad exclusion for tribally covered health care benefits. And now this slide has disappeared from my screen that I was hoping to see here. So I've got to go to my own version of the slide. Sorry for the delay. And then the final one is they eliminated the safe harbor for programs providing transportation costs and admission fees to attend educational, social, or cultural programs, because instead they added that to a different category that Wendy will be covering. So now these types of programs can be provided for all within a safe harbor, not just the elders and disabled. So that's actually a good change. From here, I'm going to go on to cover the next category, too, which is the general other qualifying assistance programs category, sort of a catch-all category for miscellaneous things. There are 6 different categories of programs for which safe harbors are provided. The first is to pay transportation costs when people have to go between the reservation or a reservation service area or service unit to facilities providing essential services to the public. The 2 examples given are medical facilities and grocery stores. Those can sometimes not be available on the reservation or in the service area, but people need to get there. The second category is programs paying expenses while the individual is receiving medical care away from home. So the bullet simplifies this, but it includes transportation costs, meals, and lodging when the member or qualified non-member needs to receive medical care away from home. The third is to provide assistance to individuals in exigent circumstances, including but not limited to victims of abuse. And the safe harbor outlines the types of assistance that may be given in this category. The next is to pay temporary relocation and shelter expenses for individuals involuntarily displaced from their homes. The next is to provide transportation costs, lodging, and meals in transportation emergencies, and to pay the cost of non-prescription drugs, including but not limited to traditional Indian tribal medicine. So the next slide, if you could go to that, discusses the key changes in the final guidance from what had initially been proposed. So the one that covers trips to facilities is broadened to cover mileage reimbursements and rental cars, not just public transportation fares, which the commenting tribal groups really found quite limited in the context of reservation life. And then also this safe harbor now covers transportation to and from designated service areas as well as the reservation. Again, broadening what had initially been proposed. The next category for transportation emergencies, it initially covered only when people were stranded off the Indian reservation. It now covers any transportation emergencies, including being stranded away from home, and that would include when you don't live on the reservation, but presumably a number of other emergencies that could arise. And then the safe harbor for non-prescription drugs added the clarification that this includes traditional Indian tribal medicine. So those are the key changes there, and I think we can move on to Wendy.
Okay, great. Thank you, Mary. And before we move on to Wendy, Kathleen, there was a question questioning whether or not scholarships, if that's a change in policy, that scholarships would now be exempt. Is that correct?
Well, scholarships for tuition, books, and fees have long been excludable from income, but the broader array of types of educational assistance that can be provided under the general welfare doctrine is addressed by, well, it was addressed by a private letter ruling issued about 10 years ago. It was addressed in the notice and now in the guidance. But I guess the change is none of this guidance really ever addressed, I guess, the distinction between a scholarship, an excludable scholarship, and an incentive award. And in fact, the new guidance doesn't even mention incentive awards either, but I just wanted to mention that we had asked the IRS to clarify that incentive awards could be treated the same as scholarships and not as taxable prizes, and the IRS didn't address that. So maybe I would say that that's an area where we should follow up with the IRS, but I was suggesting in the interim, until we do get some clarification on that issue, one strategy would be to try to basically make the incentive awards more like scholarships by requiring that they be used for education, and that would resolve the issue without going back to the IRS for more guidance. But we could have a double-track strategy.
Yeah, I think that goes to Chairman Allen's comment about how we sort of continue this conversation and put together model templates and best practices. So let's finish up with the safe harbor conversation with Wendy Pearson, who's going to be discussing the cultural and religious programs. Wendy?
Yes. All right. I'll cover the last two safe harbors. And this one is here is the cultural and religious programs, basic safe harbors, and there are 5 programs covered here. And just to be mindful of time and leave enough time for questions at the end, I'll move through the basic safe harbors fairly quickly and then highlight the key changes. So the first one is to pay the expenses to attend or participate cultural, social, and religious or community activities, including admission fees, transportation, food, and lodging. The second one is to pay expenses, same types of expenses, to visit sites that are culturally and historically significant, either on or on the tribe's reservation or the different reservation. The third is to pay costs to receive instruction about tribe's culture, history, and tradition, including language, music, and dances. If we can move to the next slide. The last two, pay expenses for funerals, burials, hosting or attending wakes, other bereavement events, and subsequent honoring events, which is in addition to the initial guidance. And then finally, to pay transportation costs and admission fees to attend educational, social, or cultural programs, either offered by the tribe or supported by the tribe or another tribe. So let's talk about the key changes there in those 5 safe harbors. So the first change clarifies that religious activities are included for the expenses that will be reimbursed for attendance or participation in activities. And it also expands the activity to either attend or participate. The initial guidance had identified attendance as the principal reimbursable activity, and tribes had requested that it be expanded to participation, and that request was heeded by the IRS. Admission fees have been added to the types of expenses we covered, but also the expense or the guidance says including but not limited to those types of expenses. So we've specifically added admission fees in this new guidance, but it's not the limit of the types of expenses that can be reimbursed. So it includes but is not limited to those. Honoring events have been added to the funeral and burial events category. The safe harbor is broadened for education, social, cultural programs to include all tribal members and qualified non-members, and as Mary was saying, not just elders and disabled. That used to be in just the elder and disabled section of the prior guidance, and now it's for every member or qualifying non-member. And then it further expands the safe harbor to include the programs, as I mentioned, both supported by the tribe as well as offered by the tribe. And all of these key changes were requested by the commenting tribes and also a part of the joint comments referenced earlier this morning. So these are very good changes and pretty much everything we've asked for. So let me move to the next slide, which is the compensation, which is the final, slightly different safe harbor. And if you recall, the general requirements for meeting safe harbor is to have your benefit not be considered compensation. This is a specific carve-out on that for compensation, and the IRS will presume that certain benefits will not be considered compensation. And these are benefits or payments made to religious or spiritual officers or leaders who are members or qualifying non-members of the payor tribe. So there are 2 types of benefits here that would not be considered compensation. The first is benefits provided under, again, a written Indian tribal government program that are items of cultural significance that are not lavish or extravagant under the facts and circumstances, or nominal cash honoraria provided to, as I mentioned, the class of recipients for this compensation safe harbor, spiritual officials or leaders, including but not limited to medicine men, medicine women, and shamans. And these would be payments to recognize their participation in cultural, religious, or social events, again, including but not limited to, and the IRS identifies the types of programs and events that were identified in the comments, but not limiting it to those. So if we can move to the next slide, I'll highlight the key changes here. So as Aaron had discussed earlier this morning or this afternoon, the facts and circumstances condition or test is added to the lavish or extravagant payments. So the tribes, commenting tribes had asked the IRS to defer to them on these traditional and cultural practices, perhaps eliminate the lavish or extravagant test. But the IRS retained that test, but has added the facts and circumstance condition, which does allow the tribes quite a bit of leeway to establish under the circumstances that the payments are not lavish or extravagant, and at the same time will circumscribe what, you know, the ability of a revenue agent to second guess the tribe on this if they can establish reasonableness under the facts and circumstances. The second key change is spiritual leaders were added. The original guidance had identified tribal officials, and so commenting tribes had requested that these payments be allowed to be made to spiritual, quote-unquote, leaders. And it does not limit the types of religious or spiritual officials or leaders to medicine men, medicine women, or shaman. As I mentioned, it says including but not limited to. So again, there is quite a bit of leeway added in this new guidance to tribes to make these safe harbor payments. And then finally, the category of honoring events was added, and again, the including but not limited to language, which would then mean that these the types of activities or ceremonies that are identified there with respect to burial and honoring events does not limit the safe harbor. You could have other activities, ceremonies, or events that could be included. So these are all very, I think, significant expansions. In this category, we didn't get the total deference that the tribes were requesting, but I believe that the expansion of the facts and circumstances test gives tribes quite a bit more leeway than they had had from the prior version. And I think that wraps up all of the safe harbors.
Well, great. Thanks to the panelists for going over and analyzing the final guidance. And what we'd like to do now, before we get to questions, is just talk in general about what this means for tribes going forward. And if I can start with Aaron Klein and whomever else wants to jump in after, just talking about the impact and what tribal leaders might want to do now that this final guidance has been issued. So Aaron?
Yeah, thanks, Dante. This kind of culminates the end from the main Treasury tax policies perspective of delving into this issue, developing this guidance, updating guidance, which I think was over 30 years old on the application of general welfare exclusion for tribes and tribal governments and tribal members. I think the focus now will shift from the IRS's perspective to training without a final guidance and a final procedure on the books. They couldn't allocate funds for training of their agents. From the tribe's perspective, I think looking at ways to make sure that documented compliance is in there, considering you know, asserting and putting in writing that their existing programs meet these safe harbors, and understanding what the safe harbors are as tribal governments consider future programs, and trying to work more with agents to pressure greater training on the agent's part, and identifying any agent that is not following this guidance. And tribes should feel free to assert the revenue procedure, which has the rule of law, as something they can rely on, and also letting somebody know higher up in the service so that they can flag this issue, like in Chrissy Jacobs' shop in Washington, because now the focus will move from the IRS's perspective to training their agents, and from tribes' perspectives to using this procedure as something they can rely on in asserting to their members and to any audits that their provision of services are excludable under the general welfare doctrine.
Okay, great. Is there any other advice that tribal leaders should take heed of in going forward?
Well, one thing, this is Mary Straight, one thing, you know, I think would be a good idea is for tribes to review their existing programs and, you know, just try to get a handle on how many of them are strong candidates to fall within the safe harbors. Some tweaking may be necessary, but maybe it's not very much. And that would be a prudent thing, I think, for tribes to do for those programs that have a shot at falling within those safe harbors.
Okay. Thanks, Mary. Is there anyone else?
Yeah,
Okay.
I mean, just as a reminder, even if a program doesn't fall within the safe harbor, that doesn't mean that it can't be offered on a tax-free basis, because one can always fall back on the traditional application of the general welfare doctrine and craft a program that is based on individual or family need for those falling outside the safe harbor.
Okay. Well, with that, we're going to move on to some questions, and I think one of the questions that might just deserve some clarification is on gaming revenue. And from my understanding, gaming revenue or revenue derived from gaming that goes into the government offers can be used to provide these programs and services. Is that correct? And I'll throw that to any panelist who wants to jump in.
Yes.
Okay. And on that compensation end of this, and I think it's a really key component that it's not included as compensation, will the recipients be required to receive a 1099?
No, since it would fall within the safe harbor and not be treated as compensation, then there would be no information reporting requirements either for 1099 or W-2. But it's important to remember these are payments to members or qualifying non-members of your tribe. So if they're from another tribe, for instance, a spiritual official or leader from another tribe, then there would be a 1099 filing requirement. Those payments would still be for services.
Okay. And also along that line, so we've heard some of the conversation around elder benefits. Would these services include stipends for elders to be able to meet their expenses? Maybe Kathleen, if you want to take that.
Yeah, that's a difficult issue. Generally, the term stipend, if it implies just a cash payment that where the elder would have complete discretion on how to use it, I fear that it would be classified by the IRS as an elder capita and subject to withholding if it's from gaming revenue, or at least to tax if it's not from gaming revenue. And of course, and assuming that another exclusion, such as for the exclusion that's recently been clarified on income from trust revenue or trust resources, didn't apply. But if
on the other hand, Kathleen, on the other hand, if it is paid only to people below a certain threshold, income threshold, it wouldn't be all that different from BIA general assistance. And there's
so
no
that would
safe
be
harbor for it.
On a needs basis. Now, I think another question is if the tribe established a program where the stipend was paid but had to be used, and there's appropriate documentation showing that it was so used for only expenses that fell within the safe harbor. I think there's a good argument that should be treated as a qualifying general welfare program. But I think I would be interested in what some of the other panelists think about that, and I think there may need to be some ongoing discussions with the IRS on it.
This is Robert. I agree with that. I think approach that Kathleen is suggesting deserves some further discussion and merit. If there is sort of a stipend, and maybe it's just limited to elders or what have you, but there are requirements that the funds be used for specific safe harbor purposes. I think that's something that really needs to be developed. But the other aspect of that, then, of course, is substantiation that we'll have to think about. How do we confirm that the funds were actually used for that safe harbor purpose, et cetera? So I think there's some real opportunity in developing these new programs.
Good. Robert, why don't we stay with you on the next question here on, and it's very specific. Would food assistance programs and lunch programs be considered part of a safe harbor?
Boy, I'm disappointed that you asked, that you stayed with me on that one. I haven't thought about that. I mean, the food example, of course, that we've got in there is the meal assistance for elders. Does one of the other panelists, have you already given some pre-thought to that?
Well, this is Mary. I don't think there are any safe harbors for food or lunch other than the meals for elder and disabled. Now, you can have a program that you develop outside the safe harbors under general principles and may be able to fashion something that would satisfy the general requirements. But a lunch is a meal. So if you have a lunch program for elders and disabled, you're likely to be fine. If you serve lunch at a community center, I'm not sure that would likely be the kind of thing the IRS would view to be taxable, because tribes have community meals often, and I don't see that as something that's going to raise particular problems for tribes. But granted, the only safe harbor for that is in the elders and disabled program.
Okay.
And likewise, in the educational context, I think it's difficult to have school lunch programs, and I don't see the IRS, in a sense, delving into that area to create a tax obligation.
Okay. Well, thanks. And our next couple of questions center around the cultural events and participation. And I think this is a really important and significant change for the IRS to recognize that as a role for the tribal government. Specifically, in regard to drum groups and attending powwows, or is that something, does it go into detail, or would that be up to the tribe? It seems as if this category would be covered, so is that correct?
Yeah, this is Wendy. I know in the comments we had specifically requested that drum groups be included and participants in the powwows. You know, the service didn't expand these these benefits beyond the you know, members or qualifying non-members. But you know, I think since they said spiritual, they added the spiritual leaders category. I think that you know, a case could be made that you know, drum group or drum leader could be certainly included in that. But you know, if any of the other panelists have thoughts about that, I would think that you know, that the addition of the tribal or spiritual leader allows some flexibility there, but that payments to these persons are certainly not included under the compensation piece, but under the cultural and religious programs piece, paying for, you know, their attendance and participation and stuff like that. But there may be some room for including them under tribal leaders under the compensation piece. Does anyone have any thoughts about that?
Yeah, there would be a question whether the nominal cash honoraria that was kind of left undefined, what is nominal. But I do agree that there's a good argument to be made that they, being integral to the spiritual event, would be a leader, I would think. It's just a question of what would be considered a nominal cash honorarium.
Okay. Well, I think in staying with that, this would cover if the spiritual leader was within the community or would be hired from outside of the community. This would still be covered under that basic service, and I think that would be up to the tribe to be able to determine the use and function of the spiritual leader within the community. Is that correct?
Right, except for that the payments to these qualifying or to these leaders or spiritual officials, the compensation exception applies only to those persons who are members of the paying tribe or qualifying non-members of the paying tribe.
Okay, great. And just to bring this up or to comment on this again, the determination of need, and Aaron, if you want to jump in on this one, the determination of need is not on a monetary basis. And if you could just elaborate on that again, that might be helpful.
Correct. It is based on, in these safe harbors, need is based on an individual's need for the service in general, and not on an income-based basis. For everything in the safe harbor, need is presumed to be met on the individual basis. And for any program outside of a safe harbor, this new dialogue now recognizes that tribal governments consider communal need in addition to individual need. So asserting communal need is in and of itself not sufficient, but this procedure for the first time recognizes that communal need is a part of the provision of general welfare for tribal governments.
Okay, great. And I think we are looking at some of the other questions on very specific things like do tribes have to include the eligible recipients? And I was hoping somebody could comment on that. I think, Kathleen, you had commented on who's eligible. Does that need to be included in a tribal benefit program, or does that have flexibility?
I think ideally the tribal eligibility guidelines should define who's eligible. And I recognize that sometimes tribes want to be flexible on that, and certainly they could still do that, include additional people on the basis of need under the traditional general welfare doctrine. But I think, again, to qualify under the safe harbor and be able to assert that it's not appropriate for the IRS to even look at the issue of financial need of the participants, you would want to include those that you expect to serve by that under that program.
Okay, and I think we're going to go to a final question, which is, what is the effective implementation date for these new policies? I think maybe we can clarify that and move on to maybe some other next steps.
Sure. So,
yeah. Okay, go ahead. Okay, the guidance is effective for benefits provided on or after December 6, 2012, which is the date the preliminary guidance came out. But as a practical matter, you can also file refund claims if benefits were reported as taxable that no longer are under the guidance for any year that's open under the statute of limitations. And that would be an application that would be made at the recipient level. And open years go back to 2011. But these can be relied on right away and to some extent backwards.
Okay, great. Great. So these are the final guidance. We should be looking at implementing these and looking to go back 3 years, which is normal IRS policy on any kind of discrepancies from the 2012 guidance. Then, thanks. I just want to thank again our panelists for their expertise on this, and thanks to all the organizations who helped put together comments and tribal leaders who have offered their comments and suggestions on how we have come to this point. So we are going to continue this conversation. If you have any questions or other comments, please send them to either me, Dante at NAFOA.org, or Brian Howard at NCAI. And there's also a couple of events where this conversation will continue. Brian, do you want to tell us about the NCAI event coming up next week?
Yeah, thank you, Dante. So we will be having our mid-year conference in Anchorage, Alaska next week, and the tax subcommittee, NCAI tax subcommittee, will be meeting Monday evening, June 9th, from 4:15 to 6 o'clock. So I know that we'll be discussing a little bit more of this issue further. And Dante, you want to talk about NAFOA's conference?
Sure. We are definitely going to, as we have in the past, continue on looking at this and getting our experts together to talk through the impacts of the guidance and how tribes can set up the safe harbors and look at best practices. That's going to take place on September 21st and 22nd in San Diego at the Hard Rock at our conference. And I think, Brian, are these slides going to be available?
Yeah, so as we're wrapping up, just to go over some last items, we will be sending out a copy of the PowerPoint presentation to everyone that registered. So even if you have colleagues that were unable to attend today, we'll make sure that they receive them. Additionally, we were recording this session, so once the file is processed, we will go ahead and upload it online and include it in the PowerPoint presentation that we'll be sending out. Additionally, if we weren't able to get to your questions today, if you had submitted them via type, those questions are archived in our system, and we will share them with our panelists for further follow-up. So I don't have anything else.
No, thank you so much, Brian Howard, and NCAI for hosting the webinar. And this concludes our session. Thank you for attending.